Hello friends, I am Dr. Vijay Kumar again, an advocate practicing the Supreme Court in Bangalore. I also reside in Bangalore. Today I want to discuss with you an important and useful subject for the public at large. How to create a will, how to draft a will, why you should do it, when you should do it, and what happens, what are the repercussions of having a will prepared. All of us own some assets, also maybe some debts. And once we are no more here, then the problem starts with the legal heirs that they want to take, few of them want to take, corner a large chunk of the property, and nobody wants to take the debts. This is a normal human tendency, and people want to get the best out of the properties that are available. Therefore, to avoid disharmony among the children and the wife and even the parents, it would be very sensible to prepare a will, clearly demarcate as to who will get what, how much, when, and about which property, so that nobody will blame each other. Ultimately, they might blame you, but then you are not there to take the blame or to react to that. So, what is a will? A will is a legal document. It tells the legal heirs what you have done with your assets, who will get what and how much, and what they should do with regard to debts. The legal aspect of a debt is that it should be recovered from the assets of the deceased person. So, in case you owe money to the bank or you have to pay it to the court because of some judgment, then in that case, they have got a legal claim on your assets, on your personal assets. In case you don't have any assets, then unfortunately, the creditors will not have any claim on the legal heirs of the deceased person. This is the legal situation. Now, how many of us write a will? In my opinion, if you ask me, depending on the court cases that we do handle, probably a maximum of 5 out of 100 would have written a will. And even people who are wealthy, well informed, highly educated, do not assume that they may die anytime. And they think they're going to live longer, and therefore they can write the will anytime later. Death does not have any age criteria. A newborn baby dies. And we see politicians living 90, 95 years, some of them even hale and hearty. And they have innumerable wealth declared officially, undeclared, Benami properties. And so you can imagine the kind of disputes that might arise among the wealthy people about the distribution of assets that the deceased person owns. So a will is a legal document, so nobody can dispute that. Can dispute depending on certain circumstances, but then the intention of the owner of the property is made clear through the will. So according to law, the Indian Succession Act 1956 clearly defines, in case of the absence of a will, how the property will be divided. We normally go for class 1 legal heirs, class 2 legal heirs, class 3 legal heirs, and so on and so forth. Parents invariably, mother invariably has a share in the property in case she's still alive. Then we have the wife, then we have the children. So these are the people who normally lay a claim on the assets. And in case you do not want to have any disputes, we have seen a lot of families quarreling among themselves. They don't talk to each other because each one wants the large chunk of the property, telling that I have taken care of the parents, or I have been close to him, I have lent him money, so he owes me money which is not documented, so I should be getting this property, and so forth. People can lie. They can tell lies just to make a claim on the property. But then, unless it's a documented debt, they cannot have an official claim on the property. And if the family is aware of that, if they are large-hearted to pay it back, they can do it. Otherwise, no. So, coming back to the definition of a will, it's a legal document making clear the intention of the owner of the assets. In this case, legally termed as a testator. One who writes the will and signs the will is called a testator. And the testator defines what the properties are and who should get how much, and what about the liquid assets, what about golden jewelry. So you can say the assets are not just properties. We normally say that properties means it's only building, land and building. It is not that. Legal definition of asset is credit balances in banks, fixed deposits, current accounts, savings bank accounts, then shares, investment in shares, investment in mutual funds, and LIC policy proceeds, sum assured being received from LICs. And then if he is working, if he has been in service and he is supposed to get PF, Provident Fund and gratuity, then those amounts. And then if he has a rental income, what about this rental income? Because the property can be given to somebody and only part of the rental income can be given to somebody. The owner of the properties has the full authority to decide what percentage should go to whom. To whom the rent should go, the proceeds or the income that is accrued of an asset, how even that should be shared, even if the asset itself is owned by somebody else, is being distributed to somebody else. So there are a lot of possibilities of how a will can be decided. So it is the intention of the creator of the will, the signatory of the will, the testator, legal terms, the testator. And how does he do this? He writes out the will in a particular format. If you are having time, you can use the services of an advocate, and the advocate will draft out a will as told by you. The will has to nominate a person as an executor of the will. Who is this executor? A person known to the executant, person who knows the family. Okay, so the person who is writing the will may say so and so will be the executor of the will, and he trusts the executor to ensure that the contents of the will are fulfilled. So he becomes responsible for distribution of assets as mentioned in the will. So we have got three major parties to a will. One is the testator who is writing out his will. The second is the executant. The third are a list of beneficiaries. It could be one, it could be multiple. So the list of beneficiaries, and we also have persons who are witnessing the creation of the will. So these are the people who generally are a party to the will. Now, what is the role of the witnesses? The witnesses and the testator of the will must sign it in each other's presence. The testator signs today, then the witnesses sign after a few days. That is not acceptable, because they should see the testator signing the will. The witnesses are responsible for that. And the witnesses must know what is the content of the will. They are supposed to keep it confidential legally. Okay, so the witnesses are aware of what are the contents of the will, and they should know that it is a will and that he is executing that will, signing the will, making clear his intentions, and he is knowledgeable about that. He knows what is being written in the will, what has been written in the will. Because sometimes he says something, and if he is not in a position to read and write, then the person who is drafting the will may do it differently. So the presumption when somebody signs and there are witnesses is that that is the real intention of the testator of the will. So the executor has some clearly defined responsibilities. The witnesses have got some responsibilities too, and a duty. And once all this in formal shape, then the will can be considered to be a legitimate wish of the testator. So now, are there cases when you can dispute the will? Yes. So if I am a testator, what should I do to ensure that the will is not disputed at a later date? What I should do is I should go and register it in a sub-registrar's office. The will can be registered in a sub-registrar office. In that case, the legitimacy of the will can never be questioned. And the other option is the will can be probated in a court of law. The will is probated, the probate also can be disputed, but a registered will cannot be disputed. So probate means that tomorrow if somebody is going to court, then the will is probated already. The presumption is that everything is okay, and that is why they had the probate done. So this is in short what the will is and how you can execute the will. Now, what is the amount that one can distribute to the legal heirs? If I am the owner of some assets, I am going to distribute the assets. Then what is the asset? So only a residue can be distributed. So what is a residue? I have got 10 lakhs with me. I have got a loan of 3 lakhs. Then the residue is 7 lakhs. So only the 7 lakhs can be distributed. Just because there is a balance of 10 lakhs in my account does not mean that all the 10 lakhs to be claimed by legal heirs. No, definitely not. Only the residue can be distributed. You must understand, if you are creating a will, you must understand this. The residue is after the debts. So you must clearly mention in the will what are your debts at the moment of creating the will. You can say my loan account number so and so. So whatever is the balance in the loan account, that will have to be adjusted. And if you owe somebody some money, even that can be mentioned there. Even if there is no document, you can say that I have taken so and so money from him. Please hand it over back to him with interest, without interest, whatever may be the terms that you had agreed. So whatever is in the will and registered will have to be adhered to. Now, why should one trust that the will has been done proper manner? So the presumption is the will is done by the testator without any external force. Nobody has coerced him. Nobody has threatened him. Nobody has intimidated him into signing the will, into favoring somebody or some set of people. So he is of a sound mind. He is not mentally disturbed. People can become emotional. See, for example, suddenly the wife dies. The husband and wife have been very intimate and getting along very well. They love each other so much. The husband becomes mentally disturbed for a few days or even months. So, the writing of the will in the minds of the witnesses, they must understand that it is made of a sound mind without any external pressure, out of his own intention. Now the will has been written, proper format, legal formats. Advocate has drafted it, attested by 2 witnesses. They know the contents of the will. Yeah, now can it be changed? Yes. As long as the testator is alive, he can change it any number of times. All he has to do is mention that all the previous wills are negated or superseded. And this is the current and forced will. Current and will which can be enforced. So any number of wills you can make. You can register the will any time, number of times. The latest will be the one which will have the effect on the assets. And the latest one can also be probated. You can probate it any number of times. Each will has got to be registered. Each will can also be probated. So when are the situations when you might need to revise the will? When you add an asset, when you add a substantial asset or another property, then you need to revise the will, because you are defined in your will, identified in your will, what are the assets, what are the shares, what are the other properties which will go to whom. So if the property is not identified, then it becomes a dispute for that particular asset. So the whole intention of drawing a will is that there should not be dispute between the loved ones. They should not be disharmony among themselves just because of the property. So that is what you are trying to say. And therefore, when there is a change in the asset holding, maybe you wanted to sell off some asset, but that asset has been willed off to somebody else, then you have to change the will because the asset no longer exists. So when there is a change in a substantial change in the asset value, addition in the assets or a depletion of assets, then you need to revise the will. Or in case the marital status has changed. Marital status has changed means either you have become a divorcee or you have become a widower or a widow. Then the position changes. Then you have to revise the will. In case there is an addition in the family, grandchildren are born, or you have another child, then again you have to revise the will. Or one or more of the beneficiaries have passed away. before you could really go away, then you have to revise the will. Sometimes it happens in an accident, maybe the few members of the family died. Then if they are beneficiaries of the will, then we have to change the will and decide it on the people who are available, who are alive. So these are the situations in which it has to be rewritten. So writing a will, keeping it, you will have to be a little aware that when the situation changes, you need to revise the will. Now registration, I just told you, registration of the will is important because then nobody can dispute the will. When we are on this subject, I want to give you a brief bird's eye view of what happens when the will can be disputed. I do not know how many of you will remember, but this is a very popular case in regard to a will. Legal circles will definitely know about this. It happened a few years ago, decades ago, probably about 10, 12 years ago, when Priyamvada Birla of the Birla Group held substantial assets in the form of shares in the Birla Group of companies, and of course, properties like buildings, investment in shares, investment in mutual funds, or whatever, fixed deposits, so on and so forth, all totaling a mind boggling 5,000 crores and more. Now, who was the beneficiary of the bill? None in the family. The beneficiary of the bill was one Mr. Lodha, a chartered accountant, who was close to the family and he was an advisor and consultant to Mrs. Priyamvada Birla. Now, once, and he was also, when he came and read out the will in his favor to the Birla family, which is a large family, there was huge commotion telling that how can a non-family member be beneficiary of such a huge volume of assets. So they said they're going to challenge the will. They said he has no business to be in the will itself because he's a rank outsider. He may be a consultant, he may be an advisor for which is paid for. It's a service which has been paid for. But Priyamvada Birla thought differently. Probably she felt that nobody was giving her a proper advice, unbiased advice like he was doing, and maybe the association was the professional relationship extended over a period of time, long period of time. So she reposed a lot of faith in him, and the entire property was left over in his favor. This shook the whole Birla family. This also shook many other families owning huge assets. As to what will each of the shareholders of such huge assets do in future. So this was an eye-opener for a lot of people, and I'm sure a lot of them would have thought about cutting short the association of chartered accountants or maybe even advocates to the families and ensure that they don't have any undue access to the people who are owning the properties. Naturally so, because the family and the Birla family went to the extent of telling that they don't mind the entire amount going to charity. They will donate the entire amount to charity. But Mr. Lodha has no business to be a part of the bill. So obviously, they took the matter to court. They took the matter to court. The court verified witnesses who had signed it. And one of the witnesses was told that he had no idea of what was in the will. But that was discounted by the court. The court was fully satisfied that the witnesses had done their job properly, the will was drafted legally correctly, and the circumstances in which the will was written and the name of the beneficiary was added, the loan beneficiary. There was no undue pressure. Mrs. Priyamvada Birla was in perfect sound mind, and there was no intimidation or no pressure from any quarters, and therefore this will was considered genuine, and Mr. Lodha was made the owner of the entire assets of Priyamvada Birla, totaling more than 5,000 crores. The will was submitted for probate after she had died. And that is when these people went to court, the Birla family went to court. But ultimately, the court decided in favor of Mr. Lodha, and he today runs the empire, part of the empire that was owned by Priyamvada Birla. Now, this I am giving you as an example of how there could be litigation by disgruntled elements, by people who feel they should have been one of the beneficiaries but are not. Maybe if among the children one has been left out, because the father didn't like or the mother didn't like the person, the son, and he's thought to be a prodigal son, and therefore they did not want to reward him with hard earned money of theirs, then this person can raise issues that the will has been manipulated. Emotionally, they can say that the testator has been emotionally manipulated to such extent to have ill will against me, and therefore I was not given any share in the property. So this can be disputed. The court will go through all the circumstances of the case, and the witnesses who have signed the will, there must be at least one witness who can testify. When the will is disputed, there must be at least one witness alive who can testify that he was present when the testator signed the will and he knew the contents of the will, and the witness also knew what was the contents of the will. So, this in general is how a will is drafted, who will draft the will, who will be the testator, who will be the executor of the will, and what the beneficiaries can do in case they are dissatisfied, and what do you do to safeguard that the will as per your instructions intentions will really be fulfilled. You have to register the will under the Registration Act. So this, my friends, in brief, is what a will is all about and why you should execute a will irrespective of what little property you have. It's not a question of what little property. You must understand that that property goes to a beneficiary without cost, and that is the instigation for people to fight because it comes free. Thank you. Please execute the will as early as possible, and in case you are in Bangalore or anywhere else, you can always contact me on my email ID dr.vijayakvarkb@gmail.com or inbox me for further guidance. Thank you and wish you all the best.